Rawr. Well, come on, Big Daddy. You don't want to play? How about you? That's what I thought. Hey! You wanna come join me?
No, if he even mentions it and it's entered in the court, I can legally go back after him and press a lawsuit on him. Oh, I know. Like I just stated, if he fucks up, and he does. If he fucks up, and he does, I can shove a lawsuit right down his throat for discrimination. Evening, sunshine.
Hi. You seem like you had a lovely day.
Yeah, the wife got caught up on the stand. I'm next. Oh, he ate himself thoroughly. Alright, now what did they call that again? A hostile witness? Not hostile. Adverse, because it falls into the same qualification. Alright, let's look into the stats as adverse witness. He's trying to get me registered as an adverse witness, which is also known as a hostile witness. Okay, here we go. The hostile witness, otherwise known as an adverse witness or an unfavorable witness, is a witness at trial whose testimony on direct examination is either openly antagonistic or appears to be on contrary to the legal position of the party who called. Let's look into this. And this is through Wikipedia currently.
No, Bob's on the thing with me.
Is either
You don't have this
antagonistic
game, so how could you?
or appears to be contrary to the legal position of the party who called the witness. Do I fall up underneath that grounds?
Yeah. Probably will.
No.
Not on the antagonistic, but the second part probably.
Appears to be on contrary to the legal position of the party who called the witness, and he called me.
And probably.
Not really. I'm going to see. During direct examination, if the examining attorney who called the witness finds that their testimony is antagonistic or contrary to the legal position of their client, the attorney may request that the judge declare the witness. Or if the attorney may proceed to ask the witness leading questions. Leading questions either suggest the answer, you saw my client sign the contract, correct, or challenge, impeach the witness testimony. Leading questions are generally only allowed during the cross-examination. So a hostile witness is an exception to this rule. What I'm saying, I do not fall under the qualifications as a hostile witness. It has to be called during my testimony. And that always brings in that. So this means you cannot do it prior to me getting up on the stand. That means he has to do it while I'm on the stand. if I'm being antagonistic. He was the one being antagonistic towards her.
But I wasn't.
In cross-examination conducted by the opposing party's attorney, a witness is presumed to be hostile, and the examining attorney is not required to seek the judge's permission before asking leading questions. Attorneys can influence a hostile witness's responses by Gestalt psychology to influence the way a witness perceives the situation, and utility theory to understand their likely responses. The attorney will interrogate a hostile witness's expected responses into their larger case strategy through pre-trial planning and through adapting as necessary during the course of the trial. So which means, I'm guessing that this late into the ball game, he cannot do that.
It would be more difficult, but he could try.
So which means he cannot call me in as a hostile witness without even speaking to me.
There's no reason for him to think you'll be hostile. He hasn't asked you anything yet.
He hasn't even spoke to me. All I've said is morning.
You asked me, you can try it now.
But you cannot with
No, I'm not you.
recall you. Yes, but
He's
not
called
with him.
you to the stand, but he has not called me.
You cannot treat him as a hostile witness.
He might try on the grounds that we're married and living
He can't.
But
We're two different people.
but also he cannot be forced to testify against you because you are married.
Exactly.
You cannot be forced to testify against your spouse.
We ought to bring that up to our attorneys, because we have been recognized as a married couple in court.
He tried getting me to say that I told children's mercy about the blaming him. Is that right?
But on the grounds I can't testify against my wife, he shouldn't be able to call me onto the stand on that. He should have chose wisely which one he was going to choose then.
Well, it sounds from what you told me before, it sounds like he's been going after her.
Yep. Which we can go back after him, considering what has happened in court for character assassination.
He ate his character assassination today.
Oh no, he's going to eat a JAG lawyer on that one once you get approved.
The only male he has over there.
Because what he told is character assassination. Singling you out like that is character assassination. PDF, the adverse witness rule. Miami at PDU.
That letter back in the mailbox?
Good. Or I'll just put it in the fucking trash can.
That's right there on the ground. You've been sitting all day. Tattoo.
So, he's trying to get me set up on that so this way he can directly ask me leading questions.
Yep.
Honey, you can fold your words into pretty bows, smile at it, and it's not being hostile.
Exactly. He hasn't even fucking spoken to me during this.
And he cannot force you to testify against her.
I'll bring that up to our attorneys in the morning. We've already been recognized in the court of law. We are common law marriage, which is to be treated as legal binding marriage in Kansas. My wife has already got up there and testified. Me getting up there and testify, that's inadvertently trying to get me to testify against my wife. It's not legal.
He asked you completely different questions. It could be.
Yep.
But he's got a 4-month time frame that he can question. And if he covered most of that today, there's not going to be enough, very much left for tomorrow.
They already did.
Well, then there's not much left.
The party calling the witness can direct the attention of adverse by the other evidence also. An adverse witness is also called a hostile witness. Judge said he's not exactly for sure on the process of registering one as a hostile witness or as an adverse witness. Still, I'm not seeing where he has grounds to even call me in as a hostile witness. He hasn't even spoken to me. The definition of evidence will make the party calling a witness to show that the witness made a prior. If that is correct, he does have to have evidence proving such.
What I'm understanding, you can't just do it right on the off.
Nope. From what I'm seeing, that is correct. He cannot. I might need your eyeballs and your understanding of this, because if what I'm seeing is correct, he does have to have proof. If you want to pan up, I can go up if you want to read that. Good.
The yellow. General evidence or bad character, but the witness, in the opinion of the court, proves adverse. The party may contradict him by other evidence, or leave or report. They prove that the witness has made at other times a statement inconsistent with his present testimony. Okay?
Before the last mentioned proof can be given, the circumstances of the supposed statement sufficient to designate the particular occasion shall be mentioned to the witness, and he shall be asked whether he did or did not make the statement.
Okay. So we need...
So what I'm getting at is he has to have evidence. Because
He has to,
have proof.
if you have made a statement under oath at a trial, which is inconsistent. Okay, you make a statement tomorrow, but it's consistent with what you've said previously under oath at this trial. It's that they're not the same. So say you called on Monday and you made a statement about...
I never have been.
No, I know. I'm giving you an example. Okay, if I was called and I made a statement about how much Pediasure's in the house, and then they call me again and I make a statement that does not agree with what I stated previously, I can be termed a hostile witness. Because what I said now does not agree with what I said before while I was under oath. So he cannot call you a hostile witness because you have never testified under oath. Therefore,
he'd have to have evidence to prove such.
He'd have to have evidence that you were under oath, you said what, such and such. Now you're under oath and you're saying something contradictory.
So which means him trying to have me called in as a hostile witness tomorrow, it's going to get thrown out.
He can't do that.
Then it's going to get thrown out.
Yeah.
He cannot.
He can't do that because you've never testified under oath at this trial.
Plus that would be treating me and her separately. We are a married couple.
And you cannot be forced to testify against her. Now if they had called you today and her tomorrow, then she could not be forced to testify against you.
And she couldn't be labeled as a hostile witness as well.
So they can't call you a hostile witness because you've not testified under oath.
Everything I've found here is saying the same fucking thing.
Yeah. So that
There it is again.
who intentionally gives unfavorable evidence against the party that called him or her as a witness. So if they call you tomorrow...
None of my evidence has even been presented in the first place yet.
But you haven't been called as a witness.
Exactly.
So you can't... So if you had, and you give...
Oh, here's something.
Okay. Okay, what is it? It's not on your side. And it's...
Hostile to your client position.
But you want to call a witness to testify in your case. But you're trying to prove that your case is better than the other ones. So he could, yes, if you're called as a hostile witness, it means that he's trying to prove that whatever you're going to tell him is for his side of the case and not your attorney's. Which is a bunch of bull. But that's what he's trying. It's a last-ditch effort to...
But what I'm finding, he's got to have grounds.
But he doesn't.
To call somebody hostile, I think you'd have to have grounds to do such.
Yeah, but he doesn't. Because you've not been a witness.
Exactly. I'd have to be a witness prior. And I haven't been. Which falls still upon that. So I'd have to be a prior witness on my side to be able to even do it, and I haven't been, so he can't.
Yeah. Not only that, but if you were, and you were saying something that is different from what you said before, then they may be able to use that. But since you've not been a witness, that throws that right out of the...
So he can't call me as a hostile witness.
He cannot call you.
What I was trying to say on this means that the witness you call to testify is not on your side, i.e. is hostile to your client's position. Nevertheless, you want to call that witness to testify in your case, in which you're trying to prove your case, not disprove the other side's.
Yeah.
For the reasons, i.e. to fill in some facts that need to be stated for you to satisfy your burden of putting into evidence all of the facts necessary to demonstrate your entitlement to bring the claims your client has asserted.
Right. So he's also trying to get you to help prove his point that the kids don't need to be here.
But from what I found due to others, he's got to have
You just
reason.
knew I would be streaming, didn't you?
And since he's not questioned you before,
I seen your stream when I jumped in the party. I didn't even know. To demonstrate your entitlement to bring a claim to your client has asserted, if the judge accepts your assertion that the witness is hostile to your case, you are permitted to lead the witness with questions like, isn't it true that the light was red when you first observed the blue car? If the witness is not hostile, the lawyer is not permitted to lead the witness, i.e. to suggest the answer to the question. All you are allowed to do is ask open-ended questions like, where were you on the 20th of March? Who, if anyone else, was still gonna have reason.
still gotta have one called
Or is it one?
and as you have not testified before the judge before, the judge has no reason to think you're hostile, so he's probably going to throw it out. Or tell him, no, he's not a hostile witness. Which means he's not allowed to ask you.
Treating a witness as hostile is a mechanism to cross-examine the witness when there are circumstances that dictate this. Here are two such circumstances. When you've called a witness in your own case in chief, but they are an unfavorable witness or an adverse witness, you may treat the witness as hostile and cross-examine the witness. You technically do not have to request permission from the judge, but it is always good form and respectful if you do request such permission.
Right.
When you have called a witness and are performing direct examination of this witness because you believe that they would testify as a favorable witness, but they start changing their story and are not cooperating, you may request permission to treat the witness as an adverse witness, aka hostile. This allows the attorney to cross-examine the witness, and he has not done such.
Nope.
So, he cannot immediately have me up on the stand as a hostile witness when he hasn't asked me jack shit.
Now,
So,
if he starts asking questions, and he perceives that you're going to be a hostile witness, then he can ask.
I would have to actually answer them in a hostile manner.
But if you
I'm not supposed to ask leading questions of your own witness, because leading questions suggest the answer. In other words, you can spoon-feed answers to your witness, and that's not what the court wants. They want you to ask opening the question so the witness can testify based on what they know instead of what the attorney tells them.
right.
For example, if you call a witness to testify that the light was red when the other side crashed into your client, the attorney cannot ask, isn't it true the light was red? Instead, they should ask what color was the light. This way, the witness answers based on their own experience. For the first question, the other side's attorney would object the question as leading.
Yeah.
I'm so proud of you.
So when I'm finding out on all of this, he cannot call me a hostile witness before I even go up on the stand.
He has to do it honestly.
Not to mention, due to the fact we are classified as legally married in Kansas, and it is acknowledged in court, he cannot make me testify against you. Which inadvertently, that's what he's fishing at.
I know. Y'all told me don't play with your food.
So, he cannot call me that.
He has to, if he perceives that Charles is being hostile, he needs to ask the judge to treat him as hostile.
Doesn't always have to, it is respectful. Otherwise there can be objections out of our lawyers of leading.
Or
And the way it's been going, it'll be sustained.
or ask an answer And they probably hear a lot of that tomorrow.
Asked and answered?
Yeah.
Probably.
Because they asked her today. They don't need to ask you the same thing. Because you're married, they don't need to do that.
He can say on the stand that question was asked yesterday.
Or you can let the attorney handle it.
Yep. They don't jump on it. I'm just going to say, well, my wife answered that question yesterday.
But I was nice to him.
Well, that doesn't matter right now.
I know. On the stand though, I answered the question. Yep. Break!
Yeah, the judge had to go off in his chambers laughing his ass off. I heard the laughter from clear back when I was sitting.
Well,
Oh, fuck, they do come out here.
Comic relief.
That wasn't just a little, that was almost complete an hour of laughing.
Oh, yeah.
But you're providing him
My dinner.
Oh, yeah.
Ooh, there's meat. Give me your teeth.
Off the side, your lawyer will take you one.
The guardian was laughing, chuckling, so was our attorney. The judge was laughing.
Reporter was giggling.
Yeah, the reporter was chuckling.
The only person that wasn't laughing, well, I wasn't laughing.
The prosecutor sure as fuck wasn't. He was getting pissed. I'm like, oh, he's about ready to have another temper tantrum.
Come here. I want food.
He was laughing.
Bring me here.
He was trying to keep from laughing.
Right after, it's like,
Usually most of witness is one that won't answer your questions. Shows a bias against you or in similar reasons. This individual says, I once had a hostile witness in a criminal case where I was a prosecutor and the witness was a cooperating criminal. He wouldn't answer my questions directly, so I asked the judge to declare him a hostile witness. Here is Federal Rule of Evidence 611.
sitting on Dustin's bed.
Yeah, Sam! Get out of there!
He's tossing all the stuff.
And right here is the Federal Rule. Yes, woo woo.
We're gonna make fun of him.
Really?
Yeah, she's gonna show the people.
Alright, I'll get on the bed.
You mean chair?
Chair bed.
Chair. Lawyers given very little latitude. The lawyers given very little latitude when questioning a witness is favorable to her positions in the case or his. The lawyer is not supposed to ask questions that suggest the desired answer. Lawyers call these leading questions. Think of them this way. A leading question essentially allows a lawyer to testify through a witness by designing questions that can only be answered in yes-no format. Questions that begin with "isn't it true that," or in themselves are statements not asking for open explanation, are leading questions as if the trial lawyer called the witness to the stand. There is a normal presumption that the witness is favorable to me. Therefore, I cannot ask leading questions. Which is what he tried getting your turn.
Except she wasn't asking leading questions.
Lynn McCraw Grant, board certified in personal injury trial by law, Texas Board of Legal Specialization. Ouch.
You know the judge is gonna find that shit out.
Huh? Which means he cannot declare me a hostile witness. The lawyer asks the court to treat the witness as hostile. The lawyer is asking permission to lead the witness to make specific points from a witness that normally does not want these points made. Normally, unless the witness is actually an opponent in the litigation or a hired expert witness for the opponent, the court will not allow the witness to be treated as a hostile witness until the witness exhibits hostility to the sponsoring lawyer's positions and testimony with non-leading opening questions. I'm taking a picture of that shit.
You could avoid his yes and no questions by saying, I don't know, or please elaborate.
He tried that shit with you.
Yeah, you saw how I handled that
He
shit.
directly tried leading you.
And he's like, I don't know, and could you please clarify the question?
Yep, that's going to be something to show our attorneys in the morning. God damn it, fucking Flash. Oh, he's gonna get fucked up tomorrow if he tries calling me up on that. Then our lawyer can ask leading questions. Ask leading questions of the witness unless the witness is on cross-examination or is being clearly evasive in the witness answers. So the lawyer is asking the judge to make the determination that the witness is being clearly evasive so as to allow the lawyer to ask leading questions. Certain witnesses are assumed to be hostile and therefore is also asked these can include opposing parties, people employed by opposing parties, or otherwise under the influence or control of opposing parties. So, he still has to have bases.
Rar.
How you been?
I've been okay. You want to come play a game with me?
Yeah, maybe.
Come play with me.
Ooh, let's play a game. Goodness.
You know you always like to. Damn, I am so freaking flirty today.
Sometimes a witness that may be helpful to your case does not want to cooperate, and therefore your client will be better protected if you can ask leading questions. It is also easier to elicit the answer you want. The attorney must request permission to treat the witness as hostile so that the leading questions are not objectionable. Let's see here. Nevertheless, sometimes a lawyer can ask before questioning if it is clear that the witness will be adverse. Well, it's not clear.
Oh, guess what? I beat the game.
Cool, you found it good, huh?
Mm-hmm. I cried.
Not good, huh?
More like... Just don't think of Dexter or Adam when you find him.
Oh.
Just don't think of them. Yes, I know, I'm cold. If you get me back to my body, I'll be fine.
These are statements right from other attorneys. And I'm taking pictures of. Yep.
I hope those one dudes aren't here anymore. They already got done eating me. They don't need to... What?
Who is it?
Hey, Kenny. What's up?
Kenny?
Yes, this is Kenny.
From South Park. Awesome. You get me, you bastards!
This is Bob.
I'm this asshole.
That!
I like this too. So how do you know Kenny?
Bob, meet Kenny. Kenny only likes dick and me.
Oh, nice.
Ha 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 ha.
Where's this Kenny located?
Wichita.
I wouldn't exactly say it's magical if you like, you know, wannabe thugs and little pissant gunbangers. Very well answered.
Ay, carambas. Meet the other one that's very protective over me.
And the children.
Now all I need is 8. Yay. Oh, my son's getting... Oh my god, where the fuck are you, bitch? I see you. Yes, I do. Ha!
So I'm fine. No, he cannot call me a hostile witness.
Oh, you're the one watching me. Fuck, 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 fuck.
The prosecutor trying to call me an adverse witness, otherwise known as a hostile witness. That's life. Now the prosecutor's trying to have me as a hostile witness before I ever get up on the stand. And he has no proof.
Eh.
He has no proof, and I have not previously testified. Well, I'm drunk.
Yeah. That's already happened. I can tell he's not shy.
You say so? That's not what I do. Fine. God, I had to pass. Maybe it's a combination of the two. Fuzzy, you made it wet, you little bastard. And what I'm finding, he still has to have proof or have me up on the stand prior. This is the first time I'm getting up on the stand under oath, so I didn't have any grounds. Because the prosecutor's raging pissed at me and my family, so to speak. Because he is very gloriously losing this case.
Hi!
What I found, he cannot have me declared a hostile witness. He has to even start questioning to begin with to even try to call me a hostile witness.
Hi!
We tried out here, it didn't work. What do you want?
I want you to see one of my inspirations.
But what I'm finding on it,
He has to actually start questioning. And even then, it has to be.
cannot have me registered as a hostile witness.
And even
can't.
then, you have to be hostile on the stand.
Yep. She has no proof. Because I've never been up on the stand. Other than that, there is no proof.
I was nice to him. Yeah, I picked him apart, but I was nice about it.
Yep. So from what I'm finding, he cannot have me declared a hostile witness.
Well, let the judge handle it. Because the judge said he will get it.
What I just found, cannot.
God
Yeah, an
damn it.
hour of the meeting.
Yep. It's going to be even worse tomorrow.
An hour, and then the judge having to take a break for lunch.
I'm trying.
No, he's trying to set it up, portraying me as a hostile witness, so that this way he can ask me leading questions.
Even
This way it
then,
leads to just yes or no answers.
even then, you could say, I don't know.
No, it summarizes
This is
down
really
to
starting to
just yes
piss
or no
me off.
questions. Or yes or no answers. What's starting to piss you off?
Well, there was someone in my game that helped me actually beat the game, and he took my last item that I'm supposed to have in the end of the game, and I'm trying to get it back now on my side, and it's not letting me get it.
Tell him to drop it. Oh, it's just not letting you pick it up. I see.
No, it's pretty much he left the game earlier today. And yeah, it was still in his possession.
So you cannot get you out of it. Nice.
No. You want something when
What is it? Comedy fit?
it's
This is really starting to piss me off because this thing right here is an artifact that you put in there, and the thing that you get from in there.
What I'm finding, he cannot label the hostile witness.
The creatures will leave you alone. This is really starting to piss me off.
And I have not previously gotten up on the stand under oath and testified. Because if I previously got up on the stand and testified and there was holes in it or whatever, it was inconsistent, then he could label me as an adverse witness. Which I have not, so he cannot. So, which means he's fucked on that part, which means it's gonna go similar to like what it did just today with you. So he's fucked. So he's fucked. He cannot call me as a hostile witness. When he has no evidence to, you know, do such.
and y'all thought I was stupid, and he thought I was stupid.
Oh, he still thinks I'm stupid, probably. He's tried that whole routine before. He tried that little routine when I went up there with Clifford. Didn't fucking work either. Oh, do you understand? Motherfucker, I completely understand, dumbass. I know exactly what the fuck you're talking about. He said he could not speak to me to the fact he's going against me in court. And I told him I'm very much aware of that now, finding out that you represent Clifford and you're going against me on the state's behalf. I cannot speak to you. I was very much aware of that. He cannot bring up that conversation during his trial because it pertains to another case. That isn't even our case.
Couple sandwiches?
Probably. Price does breakfast sandwiches. Got them before.
Just a couple sandwiches and queso?
Maybe.
Like the sausage and the cheese?
Yeah, but what I discussed with him before on Clifford's case, he cannot bring up and try to call me a hostile witness. They can't. He was trying to treat me like I was fucking stupid to begin with, that I didn't understand what he was talking about. I told him, I said, no, I get completely where you're coming from. I know exactly what you mean. Clifford was the one that... Clifford understood it as well, and still he tried this stupid routine. Clifford's not exactly stupid.
The best part? The double objection.
That was comical. Both of our lawyers stood up and screamed objection. Not to mention the fact that we are common law married and to be treated in Kansas as legal binding marriage, and he's trying to call me up on the stand as well, and he's probably going to ask questions to probably go against you. In which fact, he cannot by law.
Just refuse to ask the question or say you already asked my wife.
No, then our attorneys had better jump on it.
And if not, you can say my wife.
Oh, hi there.
Answered that question.
Now, I'll just say my wife already answered that question completely. Or done satisfied that question yesterday. Because I was the one that stood up in court to begin with when they were trying to assign us attorneys. And when they finally assigned us attorneys, I was the one that got that straightened out. They tried trading it before, like me and my attorney, wife's attorney couldn't work together. They straight up told the judge that our interests are the same. So I see no reason why our attorneys cannot work together. And I
Can
cannot
you
speak to my
help me
wife's
to win?
attorney, and or I also see no reason why I can't speak to my wife's attorney. My wife can't speak to my attorney. And the judge straight up said in the very beginning, granted. That really fucked up the prosecutor right there. I got it cleared in the very beginning. They didn't like that. Because I handled it just like an attorney would. But for him to even have me deemed a hostile witness, he has to even start questioning to begin with. And I have to be argumentative to begin with to even be classified as a hostile witness. Chances are, he's probably going to get his overruled. Because he can only ask his questions. The judge really fucked him up the other day. He can only ask witnesses questions pertaining to from January, I think it is, to April. So shit that happened during this last case, since we successfully completed the whole ordeal, he cannot ask us questions that have already been settled on matters that have already been dealt previously in court or during the last ordeal that happened after court. Cannot ask us questions based on that. He's stuck within a 3.5-month time frame that he can ask us questions from, which, to my point, is very fucking limited. The wife's to more of an extent. She was up on the stand for an hour. Mine's not going to take that long. It really isn't. There's very few questions he could actually ask me. So he found out. And I don't think he even realizes it. And I'm very seriously. My attorney pointed out, he's like, he's already got very little to go on to begin with. I'm trying to set up a hostile witness. Even if he was successful, it's still going to screw him. Now, I know where he got it from. I know where he got it from. Ooh, you stubbed the fucking toe that night, because he and me said shit. When I'm finding an adverse witness, it's not gonna fly.
Ruining. No, sir.
Well, I found it's not gonna fly.
Ruining. Nice.
I have to actually be argumentative to begin with.
Honey, I've seen you drop. I've seen you psychologically fuck people up nicely.
Oh yeah, and he's going to get it. Oh, he's going to get it. Especially for a character assassination bit. I'm going to rip his ass to pieces. Nicely. And indirectly. It'll hit him later. Pretty sure everybody else in the room is going to catch it. Except him. It's going to fuck him up. He's already psychologically beat down. And I mean thoroughly. Maybe this time the state will think twice about going up against me. And trying to drag us into court. Because this is just over the temporary custody case. Not to mention the judge already said in the very beginning that no matter the outcome of the case, the boys are going home. Yep. my lawyers already pointed out to me when we were talking to him that he's already screwed himself up. He's already got very, very, very little to go on the weekend with. Because the medical evidence has already been fucking shredded, basically. And he did it himself. And he's supposed to have 40 years of experience being an attorney. He's not doing so hot. Not to mention even just the evidence they're presenting. It would take one badass attorney to beat the evidence that I've got. And my evidence hasn't even been presented. All because there hasn't been a need.
Oh, please don't come near me. Yeah, pop on in.
Oh no, it's not looking good on the prosecutor at all. The state's thoroughly getting fucked up at work. That's okay. He's setting it up for me to shove a lawsuit for my throats. And set himself up for shoving a lawsuit down his own throat. I'm proud of character assassination.
Oh, come on, before...
Something tells me he's not going to be an attorney anymore. Nothing in that courtroom, actually. He's in for a rude-ass awakening in the morning.
Well, this guy that's coming into my game, he better knows he joins the party. I don't join others. Oh, good. He did join.
I heard him say hello.
I think I
Oh,
scared
he's
him.
in here for a second.
Yeah, I
Oh my gosh.
know. But yeah, it doesn't scare you off, which is kind of scary myself.
No, that's not going to scare me off. It's like I see, look at you and say, so, you want a sword fight, huh?
$14 just for that? Fuck no. I'll do with the fucking jump.
Prosecutor, ironically, due to the witness and shit, is still setting it up for a permanent cease and desist. Yep. I don't think the prosecutors figured out I also play chess.
Nah.
Strategic games.
Ow. Wait, what? You bought this game? Yay!
Like that you told me to. That's a fun game. You like it. The game's pretty good. Still want Yank to play it because I want to hear him scream like a little girl.
Yeah.
Good one. At least this dude's got a sense of humor.
Oh, you met him before.
I have a feeling I have. In person, however, I might have. I don't know.
You did, because I brought him over one day.
I think I might have met him in person.
He's the one that
Something
calls
like
me
that.
mistress.
Oh, yeah, that one. Here's federal rule. Ding ding.
I knew you guys were behind me. I don't need a gangbang.
But I thought you'd love it.
Not today. I need to get to the yellow flag. Ugh. It's all the way over there on that side. Ugh. Ooh, squirrel. Here, squirrely, squirrely. I have a sledgehammer with your name on it. Damn it. Waited too long. Rock. Ooh, I need to get in that water. I forgot all about the blood I had all over me. Oh, I got the gun.
Cool. How's it working out?
It helps on the last boss, but and the big boys, but the little people, it don't do well with.
Really?
Yeah. Let me fill it up, god damn it. Fine, I won't fill it. Oh, and there's some bags that I need you to make when you get in.
Ah.
Like a water bag, which I got the deer for you if you want me to pass it to you.
Just make it. It's not that hard to make.
I can only hold one.
We're in agreement. We're taking the
Yeah.
three-wheeled. The
Meaning I have one already.
Clean it out then.
It's cleaner than the blue.
Oh, that's not stand up. Yeah, we can take that one. It is collapsible. Just stick some tools and shit like that, put it in there, and that's pretty much about it.
I am taking a first aid kit with us because it's gonna be slippery as fuck.
Oh, that's a deer.
That's fine. Like I said, the bottom of it needs to be cleared out. Because I'm going to be collapsed to clear it quartz in.
Oh dear.
Yep. Off me. I'm trying to charge my goddamn controller. I'm here for you to fuck up the port.
I'm not on the port. I'm on you.
Yeah, you were getting on my goddamn cord. That's a little cord. It's a big cord between my legs.
Oh, no, I'm not.
What do you want? Oh, I'm reading the federal rules on it.
I just
Oh, trying to read.
federal one.
Unless you want to read it with me. Federal rules on it.
I still don't really care for the darkness. It's a bitch.
Well, you know you like the darkness.
God, it smells like cherries.
No shit, that's my gun.
No,
That's
it's your
for
six.
cigars.
It's like,
You don't sniff my dick like that.
because your dick don't smell good.
I got my dick all over those.
Your dick doesn't smell good. It smells like sweaty balls.
No, it doesn't.
And when you wash, it smells like freshly washed balls.
Balls are balls. What do you think they smell like?
Strawberries and mango.
Awesome, they got that kind of over
Yeah, but a chick is supposed to smell good and taste good at all times.
You're fucking with me trying to read, goddammit.
How am I fucking with you?
Because you keep moving right in my view. Quick. Yes. You will never do that. What?
Gotta be obvious right now.
Nah.
Yes, it is. Ow, bitch.
See, karma's a bitch, isn't it?
Hold me with the bottom. Ah, now my foot's cramping up.
Amendment this provision to return to the rule which prevails in the federal court in 39 state jurisdictions. As amended, the rule is not in the text of the 1969 Advisory Committee draft. It limits cross-examination to credibility and to matters testified to on direct examination. This traditional rule facilitates orderly presentation by each party at trial. Further, in the light of existing discovery procedures, there appears to be no need to abandon the traditional rule.
I'm home, love.
Welcome home.
Thank you.
No.
Yellow.
Well, I'm royally pissed.
You still can't get that piece?
No, I can't. I'm sorry, yeah, they're good new friends, but I hate it when new friends decide to come into your game, and when you're supposed to have an item in your game because it's part of winning the game, and you can't get it when they're gone, it kind of pisses you off.
Mm-hmm.
Cause it's like, dude, who was the host? I don't know, I'm just frustrated because I can't get that one fucking piece.
What, does it even show the piece there, or?
Oh, I know it's between those doors because we went to go get it.
Or is it just not showing?
I have the artifact. It's just not letting me place it. Because I had to go all the way back to the ship and get something from the ship, and then go all the way back to the snowy part, put the thing that I have in my inventory where that little door thing is, and it's supposed to open. Oh, this is gonna piss me off. Oh, it already is. This is really pissing me the fuck off. Okay. I'm just... I'm going to go over here. I'm going to light a fire. I'm going to get warm. And then I'm going to save and take a break.